Hi, thanks for joining us. I'm Katie Nobles.
And I'm disability attorney Michael Liner.
And you're watching The Bottom Line with Liner Legal. Today's topic, what medical records is Social Security going to review in my case? So Michael, break this one down for us today.
Yeah, this is a huge issue that comes up a lot. There's a lot of misconceptions that our clients have about what records are really important to have in their disability case files.
In the timeline of that,
yeah,
right?
Exactly. And you know, a lot of our clients will have long-standing disabilities or impairments that have lasted maybe their entire lives. But that doesn't necessarily mean that it's beneficial to them in the long run if we go and get a life's worth of medical records, for many reasons. First of all, what we're trying to do in a disability case is not necessarily prove that you've been disabled your entire life, although there are a few types of cases, adult-child benefit cases, in which we do have to prove disability in a specific window of time. That might be the exception here. But in most cases, we're not trying to prove you've been disabled your whole life. We're trying to prove why you can't work now, okay? And so it's so important that what we want to do is make sure that we are giving Social Security the fewest amount of records to make the most amount of impact. Here's the analogy that I try and make for my clients. If I were to give to Social Security a mountain of paperwork that went from the floor to the ceiling here, it's not likely that they're going to sit and actually read and review all of the medical records. What's more likely, at best, is that somebody's going to sit and skim through those medical records, okay? What's better, especially if we're just looking at records from a smaller time period, maybe a year before the application, something that's more reasonable, is to give them just those records that Social Security is really going to look into. Because then instead of skimming through an entire body of records, you have a much better chance of the judge or adjudicator actually reading those records and getting more in depth with why you can't work now, which is the question that we're trying to prove in our hearings. So regardless of what your impairment is, the records that we're going to get, they're going to make your case, but they're probably not going to go back 15 or 20 years. It's going to be 6 to 12 months before the application, unless maybe there's a specific type of disability case or something called a date last insured problem in your case. But in most situations, we're going to be looking for records that are more closer to the time period of the application.
So it kind of goes back to one of our earlier tips, but this applies more to records. Less is more in terms of impact.
Yeah. We want to use the smallest amount to get across the most information, just to ensure that nothing is being missed, everything's being reviewed.
All right, thanks so much for your time today, Michael. Do you have a question that you'd like to see us answer right here on The Bottom Line? Visit our website, linerlegal.com today, and submit those there.